Ladies and gentlemen, there's no question that WYLIE AITKEN, Megan DEMSHKI, John Adams, and Bill KOPENY obtained an amazing result for Mr. Sumrall. Quick facts from the police report. Defendant Juan Campos, driving to work, privately owned car, his own insurance, paid for the gas, turns into Mr. Sumrall's motorcycle. Mr. Sumrall's injuries are catastrophic. He has coma, TBI, numerous orbital fractures, colon ruptures, and I could go on and on and on. But it was put best by Mrs. Sumrall, who told me, the doctor said to me, my husband's entire body had been destroyed. His economic damages are humongous. His howl number, $659,000. His future loss of earnings, 1.49. His life care plan, 2.9. Total economic damages, ladies and gentlemen, 5.1 million. Of course, Allstate offered their $25,000 policy immediately. And to make matters worse, the defendant's employer, Metal Alloy, was in bankruptcy. So they had to go in there and pull that out of there as well. Reading that police report, talking to that client, most attorneys would say, there's really not much I can do for you. Sorry. And I don't want to take the 25s because it'd be way too much work for me to try and negotiate those liens. These brilliant lawyers decided that's not justice. They knew it was a come-and-going rule issue. They knew it was going to be tough. They filed a lawsuit anyway in Orange County. This is WYLIE AITKEN's appellate notebook. What we learned in this case is the defendant was driving from his home to a Stanton yard unpaid when the accident happened. Home to yard, unpaid. They also learned that the employee would go to the Stanton yard, pick up a truck, pick up some tools, carpool with people, and drive to the workplace, also unpaid. Corporate greed. They thought they might have a shot. They filed in Orange County. They got the OCTLA Trial Judge of the Year. His wife actually served on the OCTLA board, and that judge granted the motion for summary judgment. And what did he say? He said the words we have all heard on the coming and going rule. There's no special errand here. There's no special mission. He was on his way to work. Well, this group of lawyers were undeterred. They appeal it. Justice Miller of the ultra-conservative Orange County Appellate District, in a 3-0 decision, wrote the following. The term special errand is something of a misnomer because it implies that the employer must make a specific request for a particular errand. However, the special errand can also be part of the employee's regular duties. Thus, we have chosen to use the term business errand as it is a more precise and descriptive definition. Ladies and gentlemen, the coming and going rule that has been stoic for years has now been expanded. So, of course, Mr. Sumrall, when he got a $9 million settlement, got justice. But ladies and gentlemen, so did all of us. Mr. Sumrall, by the way, did put it best when he said, you know what? I'm proud to have my name associated on a case that gives people hope when, like me, there was none. Now, some of your clients, not all, some, have hope to get around the coming and going rule. I did some research on this. The Sumrall decision has already been cited in overturning or denying motions for summary judgment, so it's already becoming a law that we get to use. More importantly, in the research I discovered, the U.S. News and World Report tells us that 76% of Americans commute to work in their personal car. The DMV records of California tell us 15.2% of those cars are uninsured. And the United States Census tells us that in Los Angeles and San Diego, and I don't have time to go through all of them, it's a half-hour commute on average. That's a lot of cars, ladies and gentlemen, on the road, uninsured, that your clients, our clients, can get hurt and have a 15 policy, a 25 policy, or uninsured. We now have a chance to go there and to make it better. I did the math for you, by the way, just quickly. There's 915,000 uninsured cars in Los Angeles, San Diego 341,000, Orange County, 332,000. San Bernardino, 214,000. Alameda, 153,000. San Francisco, you guys are amazing. I don't think any of you guys even drive. All right, I'd like to move on to WYLIE AITKEN, right? One of the things is the firm and what have they done for the CAOC. We all know WYLIE. We all know Casey. We all know Megan. Heck, you can't go to an event in Northern Cal without running into those two, right? And Darren, too, as well. I didn't see Darren there. Sorry, Darren. We all know them. Hey, I don't have so much time. Sit down. My time is going. Sit down. We only have, we know them, right? We know what they have done for us. Even today, it was the AITKEN firm did the graphics, right? We all know WYLIE story, youngest president in CTLA, which is the CAOC. But what you might not know, in 1972, a young WYLIE flew up to the Senate to meet with an unknown senator by the name of Duke Majan, because Governor Reagan at that point just about had the votes to make no fault the law in California. WYLIE flew up there and convinced him responsibility is important, and he was the key vote in winning. So our practices all owe WYLIE. Okay, finally I'd like to say, and I'm running out of time, WYLIE AITKEN has been a personal inspiration to me before I was a lawyer. I moved out here in 1977, and within a few years of that, I read a newspaper article of a man who decided to take on a park when a mountain lion attacked a kid. Tough case, no justice, WYLIE took it. We have heard that Disneyland cannot be sued in Orange County because it's the happiest place on earth that they all love. WYLIE took them on. We now have standards that they can't sweep it under the rug. I would ask you to show WYLIE the respect he deserves, give him the love he deserves, and vote for the Sumrall case, because it has helped your practice, it has helped us, and that firm deserves it. Thank you.